What is going on with Cook County evictions these days? This is a question I've been getting a lot from clients, and on occasion I do these videos. I do these videos as a courtesy to my clients to try to have a better understanding of what's going on in the courts, but this is also something I like to share with prospective clients because a lot of people have questions about how this process works. I've done a few videos on this, basically dealing with the eviction process in Illinois generally. But not every county is the same. Some counties are much better than others at processing these cases, and the time frames are different. I practice in the collar counties and in Cook County. The collar counties are basically all the counties that surround Cook County, so Lake, Will, DuPage, Kane, Kendall, etc. Cook County is very much different than those collar counties. What I typically tell a prospective client in DuPage or Will or the other collar counties is that you can generally count on 2 to 3 months in court in trying to get your eviction process. That's gotten a little bit longer in Kane County, and I'll maybe do a video on Kane County and what the process is there. But it's in Cook County, I have to tell people to count on at least 5 months. That is, of course, if the file doesn't settle or if the tenant doesn't leave on their own. Well, why is that the case? Why does it take so long? And is there anything that the landlord can do to speed that process up? Well, let me first share what's going on in Cook County, and let me start with the point of filing. Obviously, before you file your case, there are certain things that have to be done, and I've done presentations on that as well. I'm not going to focus on that in this particular presentation, but starting from the time that you file in Cook County, there are certain things that are not only built into the Illinois law, but are built into the rules that apply specifically in Cook County. The very first thing that you're going to encounter when you're dealing with a Cook County case is that you have to use the sheriff to try to serve the summons. And for the first round of attempts at service, you got to pay the sheriff and you got to go with the sheriff. You can't get a private process server. Now, I don't care for this very much because I think it just wastes time. The sheriff, frankly, doesn't do a very good job. And that is no disrespect to the Cook County Sheriff. It's a big county. They've got a lot of issues to deal with there. So obviously this is not the biggest thing that they're focused on. I imagine a lot of the rank and file in the sheriff's office probably don't care for this law much either. But basically the law is you've got to use the sheriff on the first round of attempts. What you're going to find is that the sheriff's going to go out to the property maybe once or twice. I would say that at least half of the time they don't complete the service of process. What that means then is on the first court date, which typically, at least back in the day, was about 3 weeks after filing, you'd step up in front of the judge, you'd advise the judge that the sheriff wasn't able to get the service completed, and then the judge would pretty much grant you leave to use a private process server. Your private process servers are going to do a much better job. I find I think 70 to 90% of the time they'll get the service completed before that next court date. Sometimes tenants go out of their way to avoid service, and then if that's the case, you can ask for leave to do a posting. And a court will let you do a posting if it sees that you've been diligent in trying to get a summons served on the defendant. So right from the get-go, you've got some time that's going to get wasted. I'd say at least a month's worth of time is going to get wasted trying to effect service of process, using the sheriff. 50% chance you don't get your service completed. Okay, well, what happens after that? What about when you finally get your service of process and you're in court for the very first time with a served defendant? Well, what happens then? Well, Cook County has a new program called the Early Resolution Program, also known as ERP. What ERP is it's an attempt to deal with the flood of cases that have come into the courts after the COVID moratorium ended. The courts, like the rest of the country, are dealing with some of the fallout from its COVID mitigation strategy. So for a whole year and a half, you've had landlords who essentially, for the most part, with a few exceptions, couldn't file their evictions. And you also had the situation where the state was giving some grant money to tenants who were experiencing COVID hardships. So that was at least helping get a little bit of money into the landlord's pockets to alleviate some of the financial distress that resulted from all the COVID mitigation issues. Well, some of that's kind of coming to an end now. So what you have is you have a flood of cases coming into the courts, and the courts are just trying to find ways to deal with this. And one of the ways that they're trying to deal with this is that they're trying to encourage people to settle cases. And that's the whole goal of the early resolution program. Now, what that means for the case, though, is that on the first date that you're up where the tenant's been served, the case is automatically, almost without exception, going to be continued for 30 days. And well, actually more than 30 days, because it's kicked out for 30 days, and then you pick a date, which is a few days after that 30-day status. Well, in that 30-day time, the idea is that the early resolution program is going to try to reach out to the defendant and see if there's any willingness to settle the case. Now, I mean no disrespect to the early resolution program. Like everybody else, they have a lot on their plate. They're trying to deal with all this fallout, but they've only got a limited amount of time to deal with each of these cases. So what I find is that they really don't. Sometimes they make an effort. Sometimes I get an offer from ERP on trying to resolve the case. A lot of times in that 30-day status, I often never even hear from them. So what typically happens then on your next court date, if you haven't reached a settlement and if you don't have a proposed agreed order, you're going to step up in front of the judge and you're going to report on what happened during the ERP status. And you're going to advise the judge, we don't have an agreement. What's typically going to happen at that point then is the judge is going to transfer the case to another room. Now, there are 6 districts in Cook County. Each one of them deals with this a little bit differently, but for the most part, this is how it's going to proceed. So the judge is going to say, fair enough, you couldn't settle the case. I'm going to transfer the case to another courtroom. And what they transfer it for is what's called trial setting. Now, trial setting is not the same thing as a trial. What that means is that they're going to send you to another judge. Again, this is a way to alleviate the heavy court calls. They're going to send you to another judge on another date. And on that date that you show up, that particular judge that you've been assigned to is going to look at his or her calendar, and they're going to determine when they have time for you to come in for a trial. And this is going to vary. So some calendars are going to be much more booked up than others. Hopefully you get a date quickly, 2 weeks, 3 weeks, but it doesn't always work out that way. One thing I tell my clients and potential clients, we've been dealing with very long dates just to get statuses. So for instance, I remember we filed a few cases in March in Cook County to where they gave us dates in June. My clerk advised me the other day that we filed a few cases here in June that didn't get dates until August. That is very, very frustrating for clients. And I understand that frustration and I empathize with it. Unfortunately, there's nothing that can be done about that. We are at the mercy of the court's calendar. Well, okay, and then, so getting back to the trial setting, so you get a date for trial setting, the judge gives you a date, you go in for trial. Typically in cases like this, you're going to win. It's very rare to lose an eviction case. So you win your case, the judge puts a few weeks stay on that eviction, and then you take it to the sheriff. Well, this is another area where Cook County it just adds so much extra time to the process. In the collar counties, I tell people the sheriff's going to take anywhere from 10 to 21 days to have a tenant evicted. In Cook County, it's anybody's guess. In the 10 plus years I've been doing this, they've done it in 10 days, in 2 weeks. Other times they've taken 2, 3, 4, 5 months. It really just depends on how backed up they are. They take your file, they put it at the bottom of the pile. I don't think there's really much of a rhyme or rhythm as to how they do it. If they happen to be going out to a particular area to do some evictions, they maybe can fit yours in, and that's sometimes how you might be able to get your eviction processed faster. But basically, this is another area where you're at the mercy of the Cook County Sheriff Department. Over the years, I've had people tell me, well, I've got a friend in the sheriff's office and they can maybe get mine moved up higher in the pile. I don't think so. I don't think they're supposed to do that anyway. But even if they, I don't, even if they were willing, I've never seen that actually be successful. But again, that's something my office really doesn't deal with or get involved with. But basically, you're at the mercy of the sheriff. So just going through all this, you can see there's a lot of things built into the process that are going to delay your Cook County eviction, and that's why it takes as long as it does. Well, the more important question here is there anything you can do to speed that up? While there's not a lot of tools here to speed this process up, there are a few things you can do, very important things that I recommend that can help speed this process up. The very first thing that I recommend is to be willing to reach out to the tenant and kind of do your own settlement negotiation effort. And the reason why is, again, no insult to ERP, but ERP doesn't have a lot of time to spend on each file. And I find that sometimes I don't even get an offer from ERP. If you want to save time, it's good to be open-minded to trying to settle the case. And I know for some clients, this is something that they accept very readily. For others, this is a very hard thing to accept because there's emotions involved in this. People they're owed money. Sometimes there's hard feelings between them and their tenant. So I get the hesitation, but just looking at it from an efficiency standpoint and from a standpoint of trying to get this done as quickly as possible with as little financial loss as possible, it's good to be open-minded to being proactive about settling a case. And this is where I come in, and I'm always willing, and I tell my clients I'm always willing to be proactive about trying to settle it. I don't have to wait for ERP to reach out to the tenant. If the tenant's represented by an attorney, I can reach out to the other attorney, say that we want to have settlement talks. I could reach out to, if they're not represented, I could reach out to the tenant directly, see if they're willing to talk, see if there's something that we can work out. A lot of the settlement terms that might seem not so good at first become a lot more palatable when you realize that the process is going to drag on for 3, 4, 5 months. And at that point, you're losing all that money and all that time. So sometimes it's better to be a little bit more open-minded about accepting different terms for settlement. And again, this is where I come in. I'm happy to engage in these settlement negotiations. Costs a little bit more money, a little bit more of attorney time, but it's usually worth the effort to do it when you consider how much time and money you're going to lose by waiting for the process to work itself out. The second thing that I recommend, and I've recommended this in other videos, and sometimes this is a very bitter pill to swallow, and different clients are different. I think the more seasoned clients, the ones with more properties, have more experience with this, tend to accept this a little bit better than newer clients. But sometimes it's good to be willing to sacrifice the money in order to get back into your space quicker, to get possession of your property quicker. In the 10 plus years I've been doing this, I have obtained millions of dollars of judgments between commercial and residential property. Very little of it has ever been collected. And what a lot of people don't realize about judgments in court is that a money judgment is just a piece of paper that says that defendant owes you. You've got to go out then and try to collect that money, which means you have to do a wage garnishment. or a bank citation. And there's a lot of ways for debtors to get out of paying. They could file bankruptcy. There are limitations to how much you can take in a wage garnishment. There are a lot of deductions. There are exemptions for bank account, how much money that you can exempt from a debt collector in a bank account. So there's a lot of ways to get out of it. And typically, people who don't pay rent are usually people who are in a bad way financially. They've lost their job or they don't have a good job. You're usually not going to get paid back from someone who's in that circumstance. Even you could have a $10,000 judgment, you could have a $10 million judgment. It doesn't matter. You're not going to collect it. So I'm always happy to go to trial and get a full money judgment if that's what my client wants. But just in terms of looking out for the client's best interests, I usually recommend that the client use the money as leverage to get into the space a little bit quicker. Maybe offer to the tenant, hey, we'll waive the money, or we'll waive a big part of the money in exchange for you leaving quicker. Now, sometimes tenants don't bite on that offer because sometimes they have nowhere to go, and they're just trying to delay the process as long as possible. This is a very frustrating time. I empathize with my clients. I empathize with those potential clients who are trying to figure this process out and are just shocked by how long it takes. But as I always tell people, the law is what it is. We've got to navigate it regardless of whether we like it or not. And hopefully this was helpful. I like to do these videos. I like to provide some education, some ideas on how people can alleviate a bad situation. My goal, as always, is to get my client back in their property as soon as possible, with as little financial loss as possible, and with as little damage to the property as possible.